than any political inquiry or palace intrigue. Even asking the question, why would you now invoke the Fifth Amendment, invites an answer that may require her to waive the Fifth Amendment. We acknowledge that the criminal charge Senator Mitchell is facing is serious. That's why we represent her. For us, prioritizing her interests in that case is an easy decision. Now, of course, for an elected public figure, there are competing interests. But the senator is taking our advice and invoking her right to remain silent. Senator Mitchell, therefore, pleads the Fifth Amendment to every single question, however innocuous or theoretically collateral it may be. I am saying it for her now, and she won't say it again for the remainder of this hearing. This is a blanket invocation. Senator Mitchell will be answering no questions, period. Likewise, we as Senator Mitchell's counsel aren't going to answer questions that would by their nature require us to betray work product. That is to say, the thinking and strategy that makes up a defense. When we tried to discern the manner in which this body would conduct this hearing, what we found is that such full-fledged hearings like this are rare. And there doesn't seem to be a well-developed method by which evidence is gathered and evaluated. That should give everyone pause. To the complaint's first claim that Senator Mitchell violated Senate Rule 56.1, it's too soon to decide. Rule 56.1 reads, quote, "Members shall adhere to the highest standard of ethical conduct as embodied in the Minnesota Constitution, state law, and these rules," unquote. This means a senator can violate the rule three ways. One, conduct that violates the Minnesota Constitution. Two, conduct that violates Minnesota state law. And three, conduct that violates Senate rules. For 1 and 2, we can confidently say it is too soon to decide. Until Senator Mitchell's case proceeds through the courts, it is impossible to determine whether she violated either the state constitution or state law. To conclude otherwise is to reject due process. For number 3, we are less confident because we are not experts in the Senate's rules. But we still believe making this decision is premature until the case is fully adjudicated. And as noted before, the Senate's own rules support this conclusion. Quote, "The subcommittee may defer its proceedings until the criminal proceedings have been completed," unquote. And how can this subcommittee know one way or the other before Senator Mitchell's case plays out? Put it another way. What if the subcommittee acts now and then Senator Mitchell's case is later dismissed or she's found not guilty? Then what? To rule on the facts before the facts are determined is to pervert the concept of proof. The prudent thing for the subcommittee to do is to wait and see. As to the complaint's second claim, that Senator Mitchell violated Rule 56.2, we deny this allegation, and it's also too soon to decide. Senate Rule 56.2 reads, quote, "A member shall not publish or distribute written material if the member knows or has reason to know that the material includes any statement that is false or clearly misleading," unquote. Now this means a senator may not publish something they know is false. We categorically deny this allegation and reject its premise. We also believe it's too soon to decide. Unless and until the claims and assertions by Senator Mitchell are proven to be absolutely false, this subcommittee cannot and should not answer this question. And that proof, if it is to exist at all, will only come through the criminal court process. So once again, the prudent thing for this subcommittee to do is to wait and see. Finally, the investigation requested by the complaint could undermine Senator Mitchell's ability to defend herself in the criminal case. The complaint concludes with 3 requests. 1, investigate the true nature of Senator Mitchell's alleged unlawful, unwanted entry into an estranged relative's house. 2, investigate the ways in which Senator Mitchell's public statements conflict with the criminal complaint filed in Becker County. And 3, investigate whether Senator Mitchell's conduct on April 23rd and April 24th is consistent with the Senate's ethical standards. Engaging in these requests could undermine Senator Mitchell's ability to defend herself in her criminal case. For this reason, per our advice, she will not be answering any of these questions. When her criminal case is done, if these questions remain, Senator Mitchell is happy to subject herself to questioning by this subcommittee. But until the case is complete, she cannot do so. We will not let her do so. Thank you.
Thank you. All right. Any questions of the committee, or well, let's do the questions of the committee, and then we'll certainly come over to you all as well. Senator Miller.
Mr. Chair, don't we have to go to them first to see if they have questions, or
No,
do we do it all at the same time?
All at the same time, because remember what I did last time? We asked some questions, and then I went to Senator Grutenhagen.
Okay. Thank you.
Any questions from the committee? Senator Matthews.
Thank you, Mr. Chair. I appreciate the presentation from the attorneys. Mr. Chair, first, my observation is I've sat through a lot of hearings in this room and in this session the last couple of years, and that might have been one of the more inflammatory ones I've heard, with allegations of our political motivations, with demands of what we can and cannot do, with continued conflicting or convoluting between what is her legal and judicial standard with the court of law and what is her obligation as a member of the Senate to uphold the highest standard of ethical conduct. The parties are free to come here and make the argument of what they think that we can or can't do, but then it is up for us to decide. This allegation that we are not allowed to engage in fact-finding at this stage is ludicrous, Mr. Chair. The Senate can operate wholly independently from the judicial branch and that activity, and we can accomplish any fact-finding that we here as the Senate choose to do ourselves. What we are here and what we have continued to point out is that based on what we know so far in the exhibits, and there's a lot of information that the attorneys still want to gather, that we still want to gather, but even what we have so far is in direct contradiction to each other. Statements reportedly made to the officers in the statement of probable cause cannot be true at the same time with statements made on the personal Facebook post, as one example. The Senate can take action on members for conduct that is far less than a criminal charge. In fact, the Senate has disciplined members for things like sending tweets. We have disciplined members for attempting to bribe other individuals, getting caught, not even completing the action of bribery. We had a senator that pled guilty to a misdemeanor and left the Senate before any votes were taken during the interim of a session for a petty misdemeanor. What we have here in this case, we have multiple rungs above that. Petty misdemeanor is the lowest level. Misdemeanors are above that. Gross misdemeanors are the step above that. And then the felony charge is the highest charge that we have. And just like in a workplace, just like in a professional sports team, conduct that still falls short of being found guilty for criminal behavior, for being found guilty of a crime, still is clearly eligible by a business, by a church, by a law enforcement member, by a professional athlete on a baseball team, can still be subjected to internal discipline or ramifications on conduct that still falls short, or conduct where they're ultimately acquitted or found innocent of the charge. We'll go through and ask some questions based on some of the facts that we know. But I want to start out by saying that we should have the discussion back and forth of what both sides present, but the Senate should not and ought not be bullied into being told what we can and cannot do from a separate branch of government. Thank you.
So Senator Matthews, I thought you had a question, so you don't have a question? I wanted to give you that opportunity. Senator Miller, no, I was asking if we had any questions. That's why I asked. Senator Miller.
Thank you, Mr. Chair. And the attorney's name, I'm sorry, I didn't catch your name.
Good evening, Senator. Bruce Ringstrom, Jr.
Ringstrom?
Yes.
Okay. Mr. Ringstrom, in your testimony, you had mentioned that the Senate rules say that the judicial branch is the best forum, or you alluded to this, that the judicial branch is the best forum to determine the violation or non-violation of Senate rules. Can you tell me where that is in our Senate rules?
I did not say that, or if that is what the transcript reflects, that was not my intention. What I said was a courtroom is the best forum to evaluate such facts. I do not take issue with the idea or the notion or the propriety of this subcommittee making a determination. The point is, because Senator Mitchell is not going to put forth any testimony here, because she is taking our advice, say anything in contradiction to anything else here, this body doesn't have the same fact-finding power. I'm not telling this body what to do. I'm saying because she has a Fifth Amendment right and because she is elected to follow our advice, this body doesn't have access to that evidence.
Thank you. Mr. Chair, thank you, Mr. Chair. And even though I'm not an attorney, I'm starting to feel more and more like one as I'm sitting next to three here. I have 1 and 2 are in front of me, 3 in front of me. So I'm feeling good. But I want to make it clear, we are not here to be judge and jury. We don't all have to be attorneys. We are here to determine whether one of our colleagues violated the ethical standards of the Minnesota State Senate. That is what we are here to determine today. We have, in my mind, a lot of information in front of us where we can determine that. I have a series of questions. The complaint in front of us, I'm just going to read it, states that Senator Mitchell violated Senate Rules 56.1, 56.2, and 56.3 by breaking into the home of an elderly family member, attempting to steal the victim's personal effects, and subsequently attempting to cover up her conduct by publishing conflicting information. So, Mr. Chair, I have several questions. Would now be the right time to ask those questions?
Yes, and let me just say this. Senator Miller, when you look at the excerpt that you just read, the excerpt that you just read connects to the very thing that is being litigated through court, because any information you have in front of you has not been adjudicated. That's the point, because now how can you say if it's true that it happened, because that's what they're using as the basis for the ethics violation, by saying, hey, this person broke in there. That's a conclusion, right? And that's based on something. And so that's what's adjudicated in court, because there's a possibility that maybe there wasn't a break-in. And if there wasn't a break-in, then the very essence of this ethical complaint then doesn't stand on its own 2 feet, because now there's been adjudication of that. Now,
I appreciate that, Mr. Chair.
And so all I'm saying is, okay.
All my questions, or at least I believe the vast majority of my questions, all relate to public statements. So it's not anything that hasn't been said already. It's all public statements by either Senator Mitchell or her legal team. So I'm just going to ask my questions. And then we can determine where we go from there, Mr. Chair. So my first question is, according to the complaint, Senator Mitchell, you were booked into Becker County Jail on April 22nd, 2024, for a violation of first-degree felony burglary. Is this true?
It is false in a very specific way, because she was not booked in for a violation. She was booked in on a charge. And I think it's important that you and I that we all get on the same frequency as it relates to the language, because the nature of element 1 assumes that she was already guilty at the moment that she was booked in. I don't have any truck with the notion that there is sufficient evidence that she was booked. But anyone can be booked if they're detained.
Mr. Ringstrom or Senator Mitchell, were you arrested on April 22nd, 2024 and booked in Becker County Jail?
Senator, I defer to what I said earlier. Any question that's directed at Senator Mitchell is not going to be answered, and I'm only repeating it now for purposes of convenience.
Mr. Chair, Mr. Ringstrom, was your client arrested on April 22nd, 2024 and booked into Becker County Jail?
Probably yes. And why do I say probably? I choose to be extremely precise in this language. I think she probably was. I know for a fact she was arrested, but I want to be very clear about when it happened. I think you are probably correct, but I don't have any stronger evidence or access to evidence than you do. That's all I mean.
Thank you. Mr. Chair, and I just want to be clear, Mr. Chair and members, all my questions are directed to Senator Mitchell, but Mr. Ringstrom made it clear that she's not going to answer any questions, so I'm just going to continue to ask Mr. Ringstrom directly, but please let the record reflect that these questions are all to Senator Mitchell. So the ethics complaint in front of us states that officers from Detroit Lakes Police Department were dispatched at approximately 4:45 a.m. on April 22nd to a home that Senator Mitchell broke into, where Senator Mitchell was found hiding in the basement wearing all black clothing, including a black hat. My question is, Senator Mitchell or Mr. Ringstrom, when the Detroit Lakes Police Department arrived to the home, was Senator Mitchell in the basement wearing all black clothing, including a black hat?
Mr. Ringstrom?
I'm sorry,
No,
Mr.
I'm
Chair.
just saying, Mr. Ringstrom, that you can respond or not respond.
Senator Mitchell, once again, pleads the Fifth Amendment.
Mr. Chair, Senator Ringstrom, the complaint, the ethics complaint in front of us states that officers observed a basement window propped open. Did Senator Mitchell enter the home through the basement window?
Mr. Ringstrom?
I'm
providing a standard Fifth Amendment privilege. She won't answer any of these questions.
Mr. Chair, Mr. Chair, I almost called you Senator Bergstrom. I would have demoted you there. I don't mean to do that. At any point, did Senator Mitchell admit that she had entered the home through the window of this home?
Mr. Ringstrom?
I've already answered that question.
Can you please repeat your answer to that question?
She does employ her Fifth Amendment privilege.
Okay. I do want to point out that it is alleged by the police officer that Senator Mitchell admitted that she had entered the home through the window of the basement window of this home. So that is a public record. I'm not stating that maybe the officer is lying, but that is what was mentioned that Senator Mitchell said. So Mr. Ringstrom, the complaint states that your client had 2 laptop computers in her possession when she was arrested. And when she was questioned by police of the ownership of one of those laptop computers, Senator Mitchell told the police officer that the victim had given her the laptop, quote, way back when. This was Senator Mitchell's quote, way back when, end quote. However, when that laptop computer was opened and turned on, the screen displayed the victim's name, not Senator Mitchell's name, but the victim's name. And when the victim was asked by police, very specifically, if the victim had given that laptop computer to Senator Mitchell, she said no, she had not given that laptop to Senator Mitchell. So my question for Senator Mitchell or to Mr. Ringstrom is, when Senator Mitchell left her home in Woodbury, and the reports say that it was at approximately 1 a.m. on April 22nd, 2024, when she left her home, did she have both laptops in her possession?
She pleads the Fifth Amendment.
Okay. Mr. Chair, Mr. Bergstrom,
Mr.
was it?
Senator
Ringstrom, I am so sorry. I'm going to write this down. Ringstrom. My apologies, sir. Mr. Ringstrom, the complaint states that Senator Mitchell was released from Becker County Jail on April 23rd after an 11 a.m. hearing. Mr. Ringstrom, is that accurate?
I suspect that is probably accurate. Again, I don't have an actual record of the discharge date from the Becker County Jail, but I don't know that I would have any reason to contest that time.
Okay. Mr. Chair,
Senator Miller.
Senator Mitchell, Mr. Ringstrom, the complaint also states that that Senator Mitchell was there to check on a family member, which we have, based on some of the things that are in the reports in front of us, is not accurate. But it also says that Senator Mitchell, when she broke into the home, was carrying a modified flashlight. My question is, how was that flashlight modified?
She pleads the Fifth Amendment.
And Senator Miller, we're going to go through each one, even though they have a standing Fifth Amendment notion here.
Mr. Chair, I have several questions that are in front of us. We are here to determine whether or not one of our colleagues violated the rules of the Minnesota State Senate. And
No,
we as members of the Senate are held to a very high ethical standard. And the rules, I read them earlier, I'm happy to read them again, are pretty straightforward.
Well, Senator Miller, I think that you should read them again, because it says what we're supposed to do the very first day that we get here. The very first day is not to subject it to an investigatory notion. That's what the rules say. That's why it says on the first day that we have those options, right? Options of the delay, find probable cause. That's what, or even put it off for an investigation. That's what the rules say.
Thank you, Mr. Chair.
Senator Miller.
Mr. Ringstrom or Senator Mitchell, on the updated complaint, which I just actually started to read over today, number 11 says, during Carol Mitchell's 911 call to police, she reported an intruder in her house and asked for help. She said she didn't get a look at the intruder in the dark. I tripped over him, and he was on the floor next to my bed. He ran downstairs in the basement. Following Senator Mitchell's release from Becker County Jail, Carol Mitchell told 5 Eyewitness News, she was dressed like a burglar at the foot of my bed. I get goosebumps just talking about it. I think she meant me physical harm. There's no other reason to be on the floor of my room. So Senator Mitchell or Mr. Bergstrom, I don't know why I keep saying it. Mr. Ringstrom, my apologies. I don't know where I'm getting Bergstrom. Mr. Ringstrom, can one of you please answer why Senator Mitchell was laying on the floor next to her stepmother's bed?
She pleads the Fifth Amendment.
And Senator Miller, I go back to the fact that everything that you're talking about are allegations, right? Those are, so that's why we use the words alleged, because the way that you are describing it is definitive. And so it hasn't been adjudicated. That's the whole reason around the criminal a notion.
Thank you, Mr. Chair.
Senator Miller.
Senator Mitchell, do you feel, or Mr. Ringstrom, do you feel that your client's actions on April 22nd, 2024 adhered to the highest ethical standards as embodied in the Minnesota Constitution, state law, and the Senate rules?
She pleads the Fifth Amendment.
Mr. Chair, Mr. Ringstrom, or Senator Mitchell,
Senator Miller.
Mr. Ringstrom, do you feel that your client's arrest on April 22nd, 2024 was behavior that betrayed the public trust?
She pleads the Fifth Amendment.
Mr. Chair, I don't have any further questions at this time.
All right, so I'm going to give an opportunity for either Senator Housley or Senator Lucero to ask some questions, and then we'll go from there. Senator Lucero?
Thank you, Mr. Chair. And this would be to Mr. Ringstrom. The statement of probable cause signed by Detroit Lakes Police Chief Steve Todd. In his signature, it notes he declares under penalty of perjury that everything stated in this document is true and accurate. Do you believe that Chief Todd would sign a statement that contains false information?
Not knowingly. I don't think the chief would do that. I think the chief would sign a statement of probable cause that was presented to him by the county attorney's office, one drafted by a paralegal, and have every reason to believe that it was true. I have had criminal complaints dismissed for lack of probable cause that were signed by judges where other judges dismissed them, because sometimes mistakes happen. That is not attacking the veracity of the officer who signed the complaint. That is a recognition that charges are complex, facts are complex, and sometimes criminal complaints get dismissed despite the best efforts and honest efforts of law enforcement.
Senator Lucero or Senator Housley?
Thank you, Mr. Chair. I have a question that maybe Senator Mitchell can answer because it has nothing to do with the criminal case. The Democrat caucus has acknowledged that Senator Mitchell has done something wrong in relieving her of her committee assignments and removing her from caucus meetings. My question to Senator Mitchell, has any of the Democratic caucus asked you to resign?
That's far outside of the bounds, Senator Housley. Two things. For the first reason that you're asking whether you're intimating that the caucus says she did something wrong. The caucus has always said that she has a right to due process, and I think that's where you have to make that turn. And this is an ethical hearing. This is not about whether the caucus says she did something wrong or didn't do anything wrong. The caucus sincerely believes that she has a right to due process and that the process will play itself out. And whatever that process yields, then a decision should be made once there is that clarity. Senator Housley.
Thank you, Mr. Chair. She is entitled to due process, but we also are entitled to our Senate Ethics Committee, which we've talked about over and over, and it's a whole separate set of rules. And my question is to Senator Mitchell, has anybody from the Democrat caucus asked her to resign?
Again, Senator Housley, that is beyond the bounds. That has nothing to do with it. If the Democratic caucus told her to stay, that wouldn't prove anything. If they told her to go, it wouldn't prove anything. There are a set of facts that one should look at, and what is attached here is the underlying criminal complaint.
So, Mr. Chair.
Senator Housley.
Thank you, Mr. Chair. So, am I allowed to ask Senator Mitchell what was the reasoning they told her that she was relieved from her committee assignments and removed from caucus meetings?
You can ask, yes, but that does not have anything to do with the underlying notion.
Mr. Chair,
Senator Housley, did you have another question?
Thank you, Mr. Chair. Yes, I would like to ask Senator Mitchell if she was told why she was relieved of her committee assignments and removed from caucus meetings.
Senator Mitchell pleads the Fifth Amendment.
Thank you, Mr. Chair.
Senator Matthews?
Mr. Chair, I don't believe that you have, I think you're taking wide latitudes on deciding whether or not members can even ask certain questions, especially compared to how far you allowed questioning to go in the first complaint. I think we can, the parties that we are asking questions can decide whether they want to answer the questions or not. I would contend that it's not the role of you as the chair to decide which questions can even be allowed to be asked in this hearing. To some statements that we have in exhibits before us, Mr. Chair, and
Do you want me to address your question, or are you just going to slide past it?
if you'd like to, Mr. Chair.
Absolutely. It is the role of the chair in order to make sure that the hearing stays on task. I'm not here to answer for Senator Mitchell. I've never tried to answer for Senator Mitchell. But the moment you start bringing in caucuses and whether someone was dismissed from the caucus and what they say, what the reason, that has nothing to do with the complaint. The complaint is about her conduct and whether her conduct rises to the level that would require some action. But whether the caucus said something to her or not doesn't matter, right? This is about her complaint. Now, what they've contended is that the complaint is directly connected to certain behavior that is also tied to a criminal issue. And under our rules, if those facts are the same, you have an option to defer, but you don't have to. I'm just saying that when you get to issues about caucuses and why they say, I do think that as the chair, that's outside of the bounds.
Thank you, Mr. Chair.
Anything else, if you like. Senator Matthews?
Thank you, Mr. Chair. And if you, in your opinion, don't believe that the questions matter, it can easily be decided by the parties as to whether they want to answer or not. They are all related in the situation, just like in the last complaint. We had questions about very things connected and hypotheticals, and all of those questions were allowed in.
No, Senator Matthews, just for clarity and to be fair, every question that was asked of Senator Gruenhagen was around what Senator Gruenhagen connected to. Like, for example, the video. I asked him the question, where did he get it from? I asked whether he, where did he get it from, whether he talked to the people. Let me tell you the question I did not ask him. I never asked him, what did your caucus say to you as a result of this complaint being filed? What did your caucus say to you when it came to you saying that you sent them all the same video? Did anyone else in your caucus think it was wrong? I never did that, because that's not my business to ask that question. That's caucus business. That's the difference.
And Mr. Chair, none of the questions that you asked are the ones that I have taking issue with, but questions were asked of other parties to the complainants that went far afield. The questions were allowed in, and it's up to the parties to decide whether they want to answer or not. But Mr. Chair, in the statement of probable cause, it says Officer Sternhagen read Mitchell her Miranda warning. Is that an accurate or inaccurate statement, Senator Mitchell, Mr. Ringstrom?
She pleads the Fifth Amendment.
Senator Matthews.
Mr. Chair and Senator Mitchell, Mr. Ringstrom, you are aware, as with your experience in criminal law, and I've done some work for criminal defense attorneys as well, that statements made after Miranda warnings are given are admissible in courts of law.
Sometimes they're excluded because the Miranda warning was not properly given.
Thank you, Mr. Chair. Senator Mitchell, Mr. Ringstrom, after being read her Miranda warning according to this complaint, states that Mitchell admitted that she got into the house through the window where the bag was discovered. Are you contesting the accuracy of that statement in the complaint?
She pleads the Fifth Amendment.
And Mr. Chair, Senator Mitchell, Mr. Ringstrom, she was asked after being read her Miranda warning what got her to this stage, and Mitchell indicated that it was her father's ashes. Is that an accurate statement that's in the complaint?
She pleads the Fifth Amendment.
And Mr. Chair, Senator Mitchell, Mr. Ringstrom, the stepmother made a statement that I believe I have marked in here, where she gave ashes to Senator Mitchell in an urn the shape of a bobber. Are you contesting the accuracy of that statement?
She pleads the Fifth Amendment.
Mr. Chair and Senator Mitchell, Mr. Ringstrom, I believe Mr. Ringstrom Sr. made a statement to the Star Tribune that the Star Tribune reported on, that Mitchell was trying to make a welfare check on her stepmother. Quote, she had information that the alleged victim's cognitive abilities are steadily declining. The family is all aware that the alleged victim here has been demonstrating extraordinary paranoia and blocking people out, unquote, Ringstrom said. Are you standing by agreeing with that statement?
She pleads the Fifth Amendment.
Mr. Chair, Senator Mitchell, Mr. Ringstrom, what could you help show us to back up the claim that Mr. Ringstrom Sr. made that the alleged victim has extraordinary paranoia and is blocking people out?
Senator Mitchell pleads the Fifth Amendment.
Mr. Chair and Senator Mitchell, Mr. Ringstrom, Carol Mitchell, in a interview with KSTP, acknowledged that she was very recently diagnosed with very early stages of Alzheimer's, but the nature of the conversation and the statements back and forth with the reporter and with Mrs. Mitchell tend to demonstrate that she can carry on excellent conversations and does not necessarily show extraordinary paranoia and blocking people out. Would you agree?
Senator pleads the Fifth Amendment.
Mr. President, or Mr. Chair, I could go on with a few other things, but we're highlighting different pieces in here in the evidence, in the exhibits that have been presented to us now. A and non-A cannot both be simultaneously true. We have a statement in one place that alleges one situation and a statement in another thing, like from the complaint to the Facebook post, or the lawyer's statement to the mother-in-law's statement, where the point I'm making is that it is hard to imagine where both are true at the same time. Either one is true or the other is true. And the goal of this committee is to dig into fact-finding that the Senate Ethics Committee is allowed to and authorized to do under our rules to determine what facts are true more than others, to determine whether there has been a violation of the highest standards of ethical conduct. It's unfortunate that we are given essentially no information at all, which means that the committee can only go on the information that has been provided to us to this point, and then determine where we're going to go from here. So at this point, I have no other questions.
Senator Lucero.
Thank you, Mr. Chair. I would just like to remind the committee that Rule 56.1 says members shall adhere to the highest standard of ethical conduct, and that Rule 56.3 includes improper conduct, includes conduct that violates accepted norms of Senate behavior, that betrays the public trust, or tends to bring the Senate into dishonor or disrepute. I would draw attention to Exhibit N, which includes multiple hundreds of articles that have garnered international attention, that have brought negative fashion to the Minnesota Senate. And with that, my question to Senator Mitchell, Exhibit K is a public statement from Senator Erin Murphy in relieving Senator Mitchell of her committee assignments and removed from caucus meetings. Do you have any idea why, or can you confirm why she may have taken that action?
Senator Mitchell pleads the Fifth Amendment.
Senator Lucero.
Thank you, Mr. Chair. And this would also be to Senator Mitchell. Exhibit I, included in the packet, is a transcript of Senator Murphy's answer on the Senate floor responding, quote, yes, unquote, when asked if Senator Mitchell had been removed from the Democrat caucus. Please confirm you have been removed from Senator Murphy's caucus.
Senator Mitchell pleads the Fifth Amendment.
Senator Miller.
All right, thank you, Mr. Chair. Mr. Ringstrom, this one, I think we're going to get somewhere on this one. Mr. Ringstrom, is it a violation of state law? Would it be a violation of state law if an unwanted intruder broke into your house or broke into my house?
Mr. Williamson.
If that were proven beyond a reasonable doubt, yes.
Okay. Thank you, Mr. Chair, Mr. Ringstrom. If, in fact, your client's statement where she admitted she had entered the home through the window, if that statement is in fact true, and if that were proven true beyond a reasonable doubt, as Senator Mitchell admitted, would that be a violation of state law?
For me to answer that would require that I betray work product, which I have said I will not do.
I'm sorry, Mr. Chair, I didn't hear what he said.
For me to answer that question would require that I betray work product. That is to say, the mental effort that Mr. DeCray and I are putting forth on behalf of Senator Mitchell, and therefore I cannot answer that question.
Okay, thank you, Mr. Chair. I think I have one more, Mr. Chair.
Senator Miller.
Mr. Ringstrom, on, well, this is the old one, but number 17, I'm just going to read it here in the ethics complaint. It might be off a little bit in the new one. Well, I'm just going to read it here. According to the Star Tribune, Senator Mitchell's own attorney concluded that it was her plan to go in and out without disturbing anyone. She wanted to retrieve a couple of items that she felt were being wrongfully withheld from her despite earlier promises. So, Mr. Chair and Mr. Ringstrom, my question for you is, did you or someone from your firm or one of Senator Mitchell's attorneys say that to the Star Tribune?
Mr. Ringstrom.
I do believe someone from my firm expressed a belief in that argument, yes.
Thank you, Mr. Chair.
Members, just so that we're clear, and then we can talk about what we want to do. I think what has always concerned me about what I would see and hear is the fact that there's an inability to get the information that's needed in order to make a quality decision. And that is not because one isn't being forthright, but in the context of due process, there's a number of different things that are happening all at one time. Like, for an example, there's a lot of concern with a lot of interest when you think in terms of media. I'm not suggesting that everything that's printed in the media is true or not true. I'm not suggesting that at all, because I don't have any ill will against media. But what I do know is that the same mouth that can transfer truth can transfer error. That means that even when you say something to someone, they can filter it differently, hear it differently, write it differently, have a different motivation, and it's untested, right? And then even when you think in terms of untested statements from even the stepmother, I don't know if those things are true, but I know that there are liberties that people take, whenever they're questioning someone, or if they're doing what we call closed-ended questions or open-ended questions, like to drive and really try to get to a certain point. I'm not suggesting that's true or not, but that's why there's a process to test that information. And currently, those things are untested. And today, we've heard Senator Mitchell, through her attorney, exercise her constitutional right, which is her Fifth Amendment right. And it sounds like they're going to exercise her right to a trial, right? And really go through the process. I don't know how it's going to end up, but I'm just concerned with us taking certain information as if it's true. So let me ask Mr. Ringstrom a question. Mr. Ringstrom, it is my understanding that the next court date is scheduled for June 10th in Becker. And can you first of all verify that that's true? And then number two, will that hearing be where a person is going to plead either guilty or not guilty based on the rules of the criminal process?
Mr. Chair, the June 10th hearing is what is known as the omnibus hearing. That's often regarded as the pivot point of any criminal case. Not before an omnibus hearing may a defendant plead guilty or not guilty, so there would be an opportunity to enter a not guilty plea at that time. Typically, in cases of serious felonies, the first omnibus hearing or the scheduled omnibus hearing is not even used as such. That is to say, there may still be discovery that is exchanged. There will be an investigation that we will undertake. There may be new discovery from the county attorney's office. And so while there may be a plea at that time, it may very well be continued because more work needs to be done on both sides.
And just so that I'm clear, Mr. Ringstrom, I practice in this area too, so I also understand that, one can challenge probable cause too. They can do a number of different things. Challenge any statements or something that someone else said. But I just wanted to know and wanted the committee to know where we are or where you are in the process so that one would understand what that would mean. Senator Housley, I think you're trying to get my attention. Senator Housley?
Thank you, Mr. Chair. Only if you're done.
Oh, no, go ahead.
Okay, thank you. I have a question for Mr. Ringstrom. Mr. Ringstrom, have you been in contact with any leaders of the political parties or any leaders in the Minnesota Senate?
No, I have not.
Thank you, Mr. Chair.
Senator Miller.
Thank you, Mr. Chair. So I am going to just read something from the 911 call when Senator Mitchell's stepmother called 911, and she starts out after the dispatcher answers the phone. She said, "There's someone No, I'm sorry. Somebody has broken into my house and they just ran down into the basement. And then we have Senator Mitchell admitting to police officers. Senator Mitchell admits she had entered the home through the window. And Mr. Chair, members, Senate Rule 56.1 states the following: members shall adhere to the highest standard of ethical conduct as embodied in the Minnesota Constitution, the state law, and these rules. Nowhere in here does it say they shall not be found guilty of a crime. Nowhere in here does it say they should be arrested, alleged. It just says members shall adhere to the highest standards. And based on Mr. Ringstrom's earlier comments, that if someone breaks into someone else's home, to me, that is not adhering to the highest standards of ethical conduct as embodied in state law. Not saying anyone's guilty of anything, not being judge and jury, just stating the rules of the Senate. With that, Mr. Chair, I would like to make a motion.
Can I say something right before you make your motion?
Yes, please.
Senator Miller, you've said over and over again that you're not a lawyer and that you deal in scrap metal and you're a businessman, you have critical thinking and so on and so forth. But you're being...
You said all that, Mr. Chair. All I said was a scrap guy, but I appreciate the compliment.
Listen, because I do appreciate you as a person, but here's where you're running afoul each and every time that I'm trying to make sure there's a nexus between what you're saying and how you're trying to draw a nexus between the rule. Because first of all, you started talking about the 911 call, right? And you were talking about the 911 call as if it's true. But now, think about this. This is an unredacted copy, but Senator Miller, why don't you look at the very thing that you're reading from? Look at line 26. Line 26, I don't know if he's breaking, that is a gender issue, if he's breaking out the back window or what. Then the question was, did you get a good look at him? No, it was completely dark. And then did you go to line 32? It says, I tripped over him, I tripped over him. He was on the floor. And it keeps talking about a male. So if I'm in court, the first thing I'm going to is the fact that you're trying to say this and we're talking about a male. Now, I can keep going because it keeps giving the male dominant notion, not anything else. All I'm saying to you is that's why you go through a process so this information can be tested, because even in the midst of someone being startled, what they say is very important. So if they say he, and if you want me to keep going through there, I can, but I'm not going to do that, because all I'm trying to say is, in this context of a ethics complaint, it is directly linked and tied to this criminal issue. Yes, our rules say it doesn't have to be a criminal thing. We just heard Gruenhagen. And we just heard him because guess what? There was no criminal case alleged against him, because it doesn't have to be. But the moment you connect it to a criminal case, now you're saying, oh, okay, this is what you're using as the linkage to say that the person's standard are below our standards as senators is because of that. That's all I'm saying. Go to your motion, Mr.
Thank you, Mr. Chair. I first of all, I'm just reading from the 911 transcript.
Oh, hold it. I messed up something too.
Oh, okay. I'd like to continue.
Go ahead with your 911.
Okay, so I'm just reading off the 911 transcript.
And so was I.
And my guess is, I don't know this for sure, I've never met Carol Mitchell, but I am guessing, Mr. Chair, that Carol Mitchell did not expect her stepdaughter to break into her home. And that's probably why in the 911 transcript, she is saying he, because she didn't expect her to break into her home. But yet, Senator Mitchell was the one that was found in the basement and arrested. And we concluded, Mr. Ringstrom helped us conclude that Senator Mitchell was in fact arrested. She was found in the basement by police. So if they're not willing to answer any questions, we can only conclude based on the information that we have in front of us. And if there's a 911 transcript saying that someone broke in, yes, it says he because she didn't expect her stepdaughter to break into her house, Mr.
Hold it,
Chair.
first of all.
So, of course, if someone breaks in, and let's go from the beginning. 911 call. Someone breaks into my house. Let's go to the end. Senator Mitchell is found in the basement and arrested.
Senator Miller, we don't need to go from the beginning. You are making my point even as you speak, even when people nod their head, because you don't know. And that's why you test information.
Mr. Chair, I do know because Senator Mitchell was arrested and she was found in the basement of her stepmother's home.
But was she found next to her stepmother?
She was found in the basement.
Hold it. But was she found at? But was she found at the bed of her stepmother? Because you said that the stepmother said that the person was at her bedside.
Mr. Chair.
That's all I'm saying.
Whether or not she was laying down by her stepmother's bed, we don't know because they would not answer
That's
that
all
question.
I'm saying.
But what we do know is that Senator Mitchell was found inside the home of her stepmother. We know that. Based on the 911 transcript, it says someone broke into my house. Yes, it says he, because again, I'm sure Miss Mitchell did not ever expect her stepdaughter to break into her house.
Have you talked to Miss Mitchell?
I have not.
See, but that's my point. That all
Mr. Chair, we don't need to.
Oh, of course you do.
Rule 56.1 said members shall adhere to the highest standard of ethical conduct as embodied in the Minnesota Constitution, state law, and these rules. We don't have to wait to determine whether or not a member of our body is found guilty or not guilty. We're not judge and jury. We don't have to wait for that.
You have to, all I'm saying, from my perspective, is that you're making a gigantic leap, and you're making a gigantic leap because you're trying to get to a conclusion. All I'm saying is that it is the only responsible thing to do, from my vantage point, is to test all the evidence and the information, because something can look a certain way and not be it. That's all I'm saying. I'm not suggesting who did what. I wasn't there. I'm not even assuming that. But what I have been told is that I need to get to our 5 minutes.
Hold on one second, Mr. Chair. I just want to be very clear about one thing.
Yeah.
I am not assuming that Senator Mitchell was arrested on April 22nd, 2024.
But you're assuming the facts and circumstances around it. That's what you're assuming. Because you even said, I'm assuming that Miss Mitchell did not believe. You're not
that
assuming.
I did assume.
But you've been doing that a lot, because you're assuming things that you don't know, because we've never talked to her.
Mr. Chair, I believe I used the word assuming one time today. If I'm incorrect, I stand corrected. Yes, you are correct. I assume that Senator Mitchell's stepmother did not expect Senator Mitchell to break into her house. You are correct about that. I am not assuming that Senator Mitchell was arrested. Mr. Ringstrom helped us conclude that yes, she was arrested on April 22nd, 2024. Senator Mitchell was arrested at her stepmother's home in the basement. There's no assumption there.
But would you
That
agree,
is what happened.
But would you agree? But would you agree that the facts surrounding everything that allegedly happened on that day, we did not, nor did anyone whose information is contained in the exhibit were there? Excuse me. The police wasn't there until someone called, right? Oh, okay. So, but what I do know is that I didn't close this out in the way that we're supposed to. They've been asking questions. Now we've asked both sides questions, so we have to give them the opportunity to do their 5 minutes closing, and then we can talk about next steps. All
Mr.
right?
Chair,
So,
briefly.
I'm sorry?
Mr. Chair, briefly.
Yes.
Thank you, Mr. Chair, and I appreciate the dialogue discussion. I would contend that the points you're making of reading through indicate that the other statements made by the party is that this is just a welfare check. There's nothing, there's no there here. And we're pointing out that that's why I said A and non-A cannot both be simultaneously true. And I do have one final quick question that I'd like to ask Senator Mitchell and Mr. Ringstrom. There is more investigation that this subcommittee could do. And is Senator Mitchell or Mr. Ringstrom willing to give a release of body cam footage either to the public or to privately the Ethics Committee members here in this case for us to try to further investigate on this?
Senator Mr. Ringstrom.
We are constrained by discovery rules. We as defense counsel can't do that.
Another
And
question,
Mr.
Senator
Well,
Mitchell?
follow up, because that's not a full answer, and you represent your client, Senator Mitchell, so I believe she could make the decision to release that. Is that
No,
accurate?
she couldn't. She gets to decide whether she pleads guilty or not
Mr.
guilty.
Ringstrom, you got to wait until I acknowledge you.
I apologize, Mr. Chair.
Okay, go ahead.
I'm
Now,
sorry to both of you.
Mr. Ringstrom.
She does not get to make that decision. I make that decision. She gets to decide whether she pleads guilty or not guilty, and whether it's a jury trial or a court trial. We, as her counsel, make all other decisions. We are constrained by discovery rules.
And there's certain.
And if she wants to testify, excuse me, in her own defense at trial.
And there's some information, as you know, that you cannot release, even during discovery. There's certain information that you can't.
And there's some
sometimes
that you can,
have
Mr.
to
Chair.
sign a protective order, right, that says you can, right? So, so with that being said, if you all would take a seat over there, and we're going to have Senator Housley and Senator Lucero come back. They're going to be able to give their closing statements, which are 5 minutes uninterrupted, and then we will get to our deliberation. And as they're getting settled, here's the one thing that I want to make sure is clear. I am not Senator Mitchell's attorney. I am not defending her in any shape, form, or fashion. That's not what I'm supposed to do. But what I am supposed to do is raise issues for this body for us to think about, because that is the work of this body. Just like when you're on the other side and you're thinking about the things that you want to put forward, I just think that there is a process that is supposed to happen, and that process should happen so that we can get all the information in order to make a quality decision. That is my belief. Now, Senator Lucero and Senator Housley, you can now do your uninterrupted 5 minutes for closing.
Thank you, Mr. Chair. Mr. Chair and members of the Subcommittee on Ethical Conduct, thank you for your questions and your attention today. We know the information you've received is significant. It is never easy to stand in judgment of a colleague with whom you've worked so closely. However, the responsibility we hold as elected officials requires difficult decisions. We all pledged to uphold the Constitution and to discharge our duties faithfully to the best of our abilities. We take the oath to serve Minnesotans, and in doing so, we pledge to adhere to the highest standards of ethical conduct. We pledge to uphold the public trust, the reputation, and the honor of the Minnesota Senate. The complaint before you today highlights 3 rules within our standard of ethical conduct. Rule 56.1 a member shall adhere to the highest standards of ethical conduct. Rule 56.2, a member shall not publish or distribute written material if the member knows or has reason to know that the material includes any statement that is false or clearly misleading. Rule 56.3, improper conduct includes conduct that violates a rule or administrative policy of the Senate, that violates accepted norms of Senate behavior, that betrays the public trust, or tends to bring the Senate into dishonor or disrepute. The reason we work so hard to uphold the public's trust and abide by ethical conduct is because the public should be able to rely on what we say to the public through the media. We should be able to rely on what our representatives say to the media. If this committee doesn't trust what Senator Mitchell and her attorneys have said to the media about what happened on April 22nd, then I believe you have your answer as to whether her conduct upholds the highest standards of trust and transparency to the public.
Senator Mitchell's actions are plain violations of these three rules. Her conduct includes admittedly breaking into another person's home with the intent to remove items away from the home. Senator Mitchell's conduct includes striking such fear into a 74-year-old woman, she fled to safety of her kitchen to call the police. The victim later filed for a restraining order against Senator Mitchell and told reporters she remains fearful of Senator Mitchell. Senator Mitchell's conduct includes issuing written statements through social media contradicting what she told police. They contradicted what her attorney told reporters, and those comments are contested by the victim of the incident on April 22nd. We are not asking you to serve as the court of law. We are asking you to uphold the integrity of this institution and restore public trust. We are asking you to look at the Senate rules and ask yourself, truly, is it the norm of the Senate to be caught red-handed engaged in a burglary? Does it bring honor to the Senate to continue to welcome someone who admitted to arresting officers, quote, "I know I did something bad," end quote, and that she was in the home to take things she wanted? Does it foster public trust in the Minnesota Senate to mislead the public about serious matters such as being charged with a felony? Is the Minnesota Senate maintaining an honorable reputation when its membership condones such egregious behavior? Members of the committee, you have the opportunity to demonstrate the Minnesota Senate is a body Minnesotans can trust to serve the entire state. You have the opportunity to show that the Minnesota Senate requires its members to respect the honor placed upon them by the citizens of this great state. This committee has the opportunity to prove elected leaders are capable of holding each other accountable to their oaths of office to serve the public. Thank you, Mr. Chair and committee, for your time.
Thank you so much, Senator Housley. Thank you so much, Senator Lucero. Now the Mitchell group come and give their 5 minutes of uninterrupted closing statements. Mr. Ringstrom.
Thank you, Mr. Chair. The ethics hearing simply can't be extricated from the criminal case. That's really what's going on here. I want to make it very clear because I can't testify to many facts. I wasn't there, but I can testify to the fact that if Senator Mitchell were a member of the other party, I would be representing her just the same if she wanted me to. We deeply care about due process. And if we had answered all those questions that were asked, that would have undermined Senator Mitchell's ability to get due process in the criminal case. It may strike some of you as odd that I wouldn't take the position as to what this body should find, whether it was a violation or not, broadly speaking. But we are here to protect Senator Mitchell in the criminal case. Now, it's our recommendation that under Rule 55.11, This body should defer this hearing, defer any findings until the closing of the criminal case. One, because as we see, it's very difficult to get out evidence and to test evidence. And I hope that those complainants now recognize that some of the components of what they call evidence isn't actually evidence. They're really proposed exhibits. They haven't been tested. Senator Mitchell desperately wants to tell her story, but I am not letting her. There will come a time when this body has all the evidence it needs to make its determination. But until then, we ask that the determination be deferred. Thank you.
Thank you so much. Thank you for being here. Thank you to all that are here. Now, members, Senator Miller, you had a motion?
I do, Mr. Chair. And when you make a mistake, be the first one to admit that you make a mistake. I thought we had session tomorrow, and Mr. Chair, we don't have session tomorrow, which is why I suggested we come at 3 o'clock tomorrow to deal with the other complaint that was in front of us. So I don't know if we can go back to that, but I would recommend that we come in a little bit earlier since we don't have session tomorrow. I didn't want to interfere with session and delay that at all. That's why I recommended 3 o'clock. However, in this situation,
Oh, you guys can, you don't have to sit there. Thank you.
and council may have to help me with this, but
You guys can go out there now. Thank you.
But I would like to make a motion, Mr. Chair, that there is probable cause and that we should continue this investigation, and we're coming back tomorrow at, well, as of right now, at 3 o'clock. So my motion would be that that we move that there's probable cause and that we come back to continue the investigation tomorrow at 1 o'clock p.m.
I'll speak to that motion. One is, according to the rules, and unless Senate Council tells me I'm wrong, there does not have to be a finding of probable cause in order to do an investigation. Two, an investigation requires much more than showing up the next day. It requires, preparation, witnesses, and just a number of different things outside of just the witnesses here. Three, I think that has been very clear from what has been put forward that we will not get as much information in that investigation that we need, especially if the main subject of the investigation is not able to or is unwilling to give information because there is another criminal proceeding that's going forward. So I would not support that motion, but that's your motion, and we can vote. All those in favor of the Miller motion, say aye.
Aye.
All those opposed, say no. No. So, Senator Kunesh.
Thank you, Mr. Chair. I would like to make a motion to defer these proceedings until the criminal proceedings have been completed and we have more information to work from.
I support that motion. Senator Matthews.
Thank you, Mr. Chair, and I would argue that that does not fit under 55.4, which tells us to vote to defer action until a certain time. And unless that we can state what a certain time would be, council's indicated the June 10th date may not be the certain time. It could be continued after that. This is not something that we can just leave hanging over the Minnesota Senate, which is why I think the better motion would be to proceed with an investigation that allows the investigation and the criminal complaint to go through on their separate track that they're doing, and allows the Senate Ethics Committee to make their fact-finding and investigation, which is within our rights to do.
Senator Matthews, I would turn you to 55.11. 5511 says, if criminal proceedings relating to the same conduct have begun, which they have, the subcommittee may defer, which is permissive. It is proceeding until the criminal proceedings have been completed. That is certainly an option. To get to maybe a compromise is because we can't do, not can't. I think it would be challenging to do an investigation simultaneously while the criminal piece is going on, is because there's information they can't share with us and we can't have access to that I believe that we should have access to. And if we want to make sure that we want a time certain, we can come up with a time certain even after the June 10th, because after that date, we can find out and know what will the next hearing be. And we can meet every time after those hearings in order to reassess and see where we are, because there might be the possibility if there's been an admission or if there's been an exoneration or whatever, we then have more information and we're not losing sight of it. Senator Matthews.
Thank you, Mr. Chair. And I appreciate you pointing out that it is permissive that we may defer. I believe that the deference to a time certain should be to tomorrow, as we discussed, that we're already coming in, because we have 2 weeks left of the legislative session. And there are things that this committee should be thinking about for at least how this rest of the session ends up playing out. Because these dates are beyond after the session. And so we will be forcing a member to continue to have to prepare for a criminal complaint while making numerous decisions at late nights that are on the Senate floor. And many people have pointed out, everybody else in life, at the very minimum, gets put on some form of leave while they get to focus fully on preparing for their criminal complaint. So we should consider action for, at the very minimum, what the rest of this session needs to happen. And that's why the time certain should be to tomorrow afternoon when we are here anyways.
Senator Matthews, this is where it gets a little tricky, is because due process and giving someone due process should not be tied to whether we're in session or not. It has to be tied to when we have the information and providing people the folks the opportunity to be heard. Now, it's interesting that you use other folks on administrative leave, is because if you look at the history of this body, even when someone's charged with a felony or someone's going through a criminal proceeding, someone has been gone through a federal court, we always, historically, have allowed that criminal proceeding to play itself out, and then we make a determination based on the information that we have. Now, Senate Council's here. You can ask Senate Council if what I'm saying is true, and we should not treat Senator Mitchell any differently than anyone else. We talked about how there needs to be equality and fairness when we think in terms of the way we deal with our members. Then if that's true, then what we've done historically is waited until the criminal proceedings were done, and if someone was found guilty, they were dealt with. If someone, if even, not even whether it's the most serious charge, because you made the statement earlier that there was a person who did a low-level offense, and in fact, that's what they were guilty of criminally, but the Senate said no. You tried to bribe the person to tell them not to tell that you had taken this code or whatever this low-level theft thing was. And that, and those were the things. But guess what? They waited until the process was done. And I believe that we need more information, and I think our rules are clear as far as that is concerned. So there's a motion before the body, which is Senator Kunish's motion for us to defer until after the Until after the criminal proceeding. I was just given another idea as far as when we could potentially, keep coming back in order to make sure that we're monitoring the case itself, and that would be worth it. Senator Miller?
Nope,
Oh,
I have
no,
another motion if this
Okay.
one,
Okay, so.
depending on what happens with this one.
So seeing that, Senator Kunis's motion is for us to defer until the criminal proceeding has ended. All in favor say aye. Aye. All those opposed say no.
No,
All right, we're at an impasse there.
I have another motion, Mr. Chair.
Senator Miller.
All right, I think I have the one that can bridge the gap, Mr. Chair. So I would move that the Subcommittee on Ethical Conduct finds there is probable cause to believe that the violations outlined in the Senator Mitchell complaint occurred. That's my motion.
That's his motion. All in favor of that motion say aye.
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 All those opposed say no? No. I make the motion that we did delay this until a time certain. We should find a date after the June 10th hearing, come back and see exactly what happens at that June 10th hearing, and then we can determine what our next step should be. If she makes some admission or she does something else, we'll at least have that information. And we can still respect the due process. We can still respect the fact that we're not just pushing it off and you don't have a time certain. So if I was looking at a date, just so that in my motion I have a time and date certain, it looks like the June 10th hearing is on a Monday. We could do something on that Friday, the 14th. Or if there's a day after that June 10th that you want to come back, we can make that happen so that at least that we have the information.
Mr. Chair, I don't want to come back.
Well, but, I mean, it is the responsibility that we have. We could do something by Zoom and notice everyone, and the public can still be engaged, because I know that you're away. I was sensitive to that even when we were doing our other hearings. So my motion is that we delay it to a time certain, June 14th. That gives us an opportunity to see what happens at the June 10th hearing, and we have more information. That's my motion.
Senator, I'm not available on the 14th,
Is there another day?
or the 18th, Tuesday the 18th.
I can make Tuesday the 18th work. So the motion is that our motion is for us to delay it to a time certain, which is June 18th, which gives us an opportunity to see what happens at the June 10th hearing, and we can certainly come back and not drop it so that we can stay committed to this process. Ready to vote?
I'm ready, Mr. Chair.
All in favor say aye. Aye. All those opposed say no.
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 All right, I'm going to go through I think we've gone through everything, and if we don't come up with anything, then we're at an impasse, and then we will adjourn with nothing.
Mr. Chair, I'd like to move for a recess for about 10 minutes.
Okay,
Allow for a chance to have some more thought, more conversation, rather than continuing to rattle this off in rapid fashion. I think a small pause and a chance to collect our thoughts and
Please.
discuss amongst ourselves would be good.
and just so everyone knows that we've gone through, proceed with an investigation, right? And then we also did a vote to defer action till a certain time. And we also did that there should be a finding of probable cause, and that was struck down. And the only one that we haven't done is a finding of no probable cause. And so you can take your time, you said in about 10 minutes?
Mr. Chair, before we recess,
Yes.
is it possible to get agreement amongst the subcommittee members that we come back a little bit earlier tomorrow for the other one rather than 3 o'clock p.m.?
I'm sorry that huh?
I'm booked till 3 tomorrow.
Yeah, I'm booked.
Okay. All right.
the early
That
part
answers
as
that
well.
question. Thank
Unless
you.
I would have been happy to, but. All right, so members, it looks like, do you guys want 10 or 15 minutes?
10 minutes is fine.
10 minutes? Members, the committee is in recess until 8:50. The committee will come back to order. We wanted to spend a little time to see if there's something else that could be figured out. Senator Miller.
Thank you, Mr. Chair. I'm just trying to figure out what our options are. If we wanted to come back at a time certain, maybe do an executive committee or do something else at a time certain, is that option still available to us if we could agree on that?
Yeah, oh, absolutely.
Okay.
Senator Matthews.
Thank you, Mr. Chair. So as you indicated earlier, we've had several votes on several of the actions given to us in Rule 55.4. We voted on proceeding with an investigation. We voted on voting to defer action until one specific certain time. The last one that's in Rule 55.4 is a motion to find no probable cause. Mr. Chair, I'm going to make the motion to find no probable cause. I'm going to ask for a roll call, and I'm going to urge the committee to vote no on that motion. That way we have at least a vote on all of the actions that are indicated in Rule 55.4. Depending on the outcome of that vote, then there may be other variations we discuss, but to cover everything in Rule 55.4, that's my motion.
Well, that is the Matthews motion. All in favor of finding? Roll call. Oh, roll call requested? Okay. Roll call requested, roll call granted.
Senator Kunish.
I'm sorry, would you please clarify that motion one more time?
It's finding of no probable cause. It's just saying that there's no probable cause.
Mr. Chair.
Senator Matthews.
Thank you, Mr. Chair. My motion is to make a finding of no probable cause. I have asked for a roll call vote, and I'm urging the committee to vote no on the motion I am making.
It's fine.
Senator Kunish.
No?
Senator Champion.
No.
Senator Miller.
No.
Senator Matthews.
No.
Senator Matthews.
I don't know if you want to announce or
yeah.
not.
Oh.
Sorry.
There are 0 ayes and 4 nays. The motion does not prevail.
Mr. Chair, thank you. Something definitely needs to give because half of this committee has voted that there is no probable cause and then voted that there is not no probable cause. A and non-A cannot be true at the same time. So my votes have been consistent with the fact that there is probable cause in all respects moving forward. So I'll defer to Senator Miller with an idea.
Senator Miller.
So the scrap guy knows 1 + 2 is 3, and that's the number we have to get out of here tonight. So I have a motion that hopefully gets us to 3, maybe even 4. Mr. Chair, I would like to make a motion that we come back tomorrow at 4:00 p.m. in executive committee.
I would say no to that motion. I would not vote in support of that motion. I think if we're going to do a time certain, that it should be June 18th. That would give us an opportunity to see what happens in the other proceedings, and we have more than enough information, and therefore we're not holding up anything. So, but that's your motion. All right.
Motion.
So
Doesn't sound like I'm going to get my 3, Mr. Chair.
To the Miller motion, all in favor say aye.
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 All those opposed say no. No. I'll try again.
Mr. Chair, I'd like to make a motion that we move into executive committee right now.
See 3 hands. Got to be 3 hands. All right, then we can go into executive committee.
All right, excellent.
And Shamika has.
Yes. 11.
1150, I think 1150.
That is correct. It's just as.
And that is difficult, is only the 11? I'm calling the meeting back to order. Members, we had an opportunity to talk during an executive committee. You also know that that committee gathering is recorded for transparency purposes. Members, I am going to renew a motion for us to return on June 12th. The significance of June 12th is that it gives us an opportunity to see what happens with Senator Mitchell on June 10th. And then at least that we get a chance to come back and figure out what's going on and what our next steps will and should be. What we also, I'm also agreeing to as a part of this motion is that if we hear of and find out anything else of substance that would require us to come back, that we will contact each other and agree that we'll try to get together as soon as possible, because all four schedules have to line up. And we're committed to that. We're committed to just making sure that we get information and that we can proceed in a rightful way. So that's the motion. Motion for us to return on June 12th at 11 o'clock. We will instruct staff to identify and find us a room, and the notices will go out, and we will go from there. That's my motion. All right. All in favor say aye. Aye. All those opposed say no. The motion prevails. The committee is now, I want to say one other thing. This same room, MSB 1200, has been reserved for us reconvening tomorrow, which is May 8th at 3 o'clock for the deferred motion on the Gruenhagen matter. Why can't I talk now? I'm sleepy. And Shamika Bogan, my executive assistant to the president, has already sent a calendar invite for the committee members, okay? And I want to thank everyone for being here tonight. Alexis Varner, who just did her last final in school, so she had to get a little replacement, and Shamika and Alexis, our Senate counsel, we are grateful for her guidance as well. With that being said,
Mr. Chair, can I just say one thing? I just want to echo your comments to share our appreciation, united as the four members of the Senate, to all of our staff, because they've been putting in a tremendous amount of work, time, and effort, not only for this subcommittee hearing, but as we prepare for the last week or so of session. So all the staff, we appreciate everything that you all do.
and with that, the meeting is adjourned.